Brazil that are stealing our intellectual property. Also want to talk about what I think is the exploitation of the Americans with Disabilities Act, particularly around website access. The web didn't exist, and now we have attorneys filing a number of frivolous lawsuits. Would like to get some feedback on that after you get confirmed. And finally, I want to make sure that you recognize in the First Step Act that faith-based organizations that have proven to help reduce recidivism are absolutely in play for the First Step Act, and hopefully we can make sure the Department of Justice move forward with that. Thank you, Mr. Chair.
Thank you, Senator.
I believe that's the end of the first round. Mr. Barr, you're able to go for a little bit longer?
Sure.
Okay. So we'll do 5 minutes. As you can tell, I've been pretty liberal with the time, but let's try to honor it the best we can. Senator Grassley.
Okay. Where he left off on working with faith-based institutions, you were very positive about that?
Yeah, absolutely, Senator.
That takes care of my first question. Enforcement of the antitrust laws is extremely important to ensure that markets are fair and participants don't engage in abusive activity harming consumers. I've been particularly active in making sure that the Justice Department and Federal Trade Commission carefully scrutinize mergers, as well as looking out for anti-competitive behaviors and predatory practices in certain sectors of the economy, and particularly in my state of Iowa, the agricultural industry, but I'm also pursuing things in healthcare. In particular is because I will be chairman of the Senate Finance Committee. I'm interested in making sure that companies in drug and healthcare industries are playing by the rules. Everyone's concerned about the high cost of healthcare and especially the skyrocketing price of prescription drugs. Do you agree that the Justice Department has a very important role in this area?
Yes, Senator.
And would you commit to making antitrust enforcement a priority?
Yes, it has to be a priority.
Okay, thank you. Now to a favorite issue of mine, whistleblower protection. Whistleblowers, as I told you in my office, are very critical to exposing waste, fraud, and abuse. There are eyes and ears on the ground. Their courage when they have it, and most of them do have great courage, or they wouldn't come forward to expose government malfeasance. That's how important they are. So I hope I can have you have a favorable view towards the opportunity to listen to whistleblowers, protect them from retaliation, and promote a culture that values important contribution from those patriotic people.
Absolutely, Senator.
Okay. Now to the Foreign Agents Registration Act. I hope you understand there have been very few prosecutions under the Foreign Agents Registration Act since 1938. And so that lax enforcement, I think, is getting, obviously, even since the Mueller investigation, getting a lot more attention now. But we had a hearing on it before the committee, and I think it proves that we should see more transparency and more enforcement against bad actors, not less. Do you agree that the Foreign Agents Registration Act is a critical national security and public accountability tool? And if confirmed, will you commit to make sure that that act is a top priority?
Yes, Senator.
Okay. So then getting back to legislation that I think will improve that 1938 Act, I introduced the Disclosing Foreign Influence Act to improve transparency, accountability, and enforcement. You haven't probably read that act, but I'd like to work with you, even though it's not in this committee, it's in Foreign Relations Committee. I'd like to have you work with us so it's something that we can pass and make sure that this law is more useful than it has been over the last 80 years. I support the Freedom of Information Act and the public disclosure of government records. Transparency yields accountability. You hear me say that all the time, and that's true no matter who's in the White House. When I was chairman of the committee, I helped steer FOIA Improvement Act into law, which creates a presumption of openness, and that presumption of openness is a very important standard. The Justice Department oversees the federal government's compliance with FOIA. So I hope you would agree that FOIA is an important tool for holding government accountable. And if confirmed, then would you make sure it's a top priority to make FOIA and the faithful and timely implementation of the 2016 amendments a top priority?
Yes, we'll work hard on that.
Because you know what really happens in the bowels of the bureaucracy? It just takes them forever because maybe something's going to embarrass them, so they don't want it out in the public. So you get all sorts of excuses. We got to do away with those excuses. One way to make FOIA work better is by reducing the number of requests. This will have to be my last question. One way to make FOIA work better is by reducing the number of requests that have to be made in the first place. That's why I'm a strong advocate for improved proactive disclosure. If confirmed, will you commit to help advocate for more proactive disclosure of government records? Now, that's not just by the Justice Department, but because your government or your department's top dog in this particular area in the federal government overall.
Yes, Senator.
Thank you.
Thank you. Senator Feinstein.
Mr. Barr, I see you have staying power, and I see it runs in the family, and particularly your grandson. I'd like to send a little care package down to him. He deserves a medal.
We'll get that to him. There you go.
Thank you, Senator.
You're welcome.
He doesn't have to share it with the rest of the family.
In 1994, you said that gun control is a dead end. It won't reduce the level of violent crime in our society. The year you made this comment, I introduced a federal assault weapons ban, and the president signed it into law. A 2016 study shows that compared with the 10-year period before the ban was enacted, the number of gun massacres between 94 and 04 fell by 37%, and the number of people dying from gun massacres fell by 43%. In addition, between 2004 and 2014, there has been a 183% increase in massacres and a 239% increase in massacre deaths. Do you still believe that prudent controls on weapons won't reduce violent crime? And if so, what is your basis for this conclusion?
I think that the problem of our time is to get an effective system in place that can keep dangerous firearms out of the hands of mentally ill people. That should be priority number one, and it's going to take some hard work, and we need to get on top of the problem. We need to come up with agreed-to standards that are prohibitors of people who are mentally ill. We have to put the resources in to get the system built up the way we did many years ago on the felon records and so forth. We have to get the system working, and as I say, it's sort of piecemeal a little bit right now. We need to really get some energy behind it and get it done. And I also think we need to push along the ERPOs so that we have these red flag laws to supplement the use of the background check to find out if someone has some mental disturbance. This is the single most important thing I think we can do in the gun control area to stop these massacres from happening in the first place.
Well, thank you. I'd like to work with you in that regard. Yes. In August of 2002, the Justice Department's Office of Legal Counsel issued opinions authorizing enhanced interrogation methods that included waterboarding and extended sleep deprivation. These opinions were later withdrawn, and the Justice Department's Office of Professional Responsibility found that they reflected a lack of, this is a quote, a lack of thoroughness, objectivity, and candor, end quote. In 2015, I worked with Senator McCain to pass legislation making clear that enhanced interrogation techniques are unlawful and limiting authorized interrogation techniques to those listed in the Army Field Manual. And that is the law today. If confirmed, will you ensure that the Justice Department upholds the law?
Yes, Senator. I think that was an important change because I think it gave clarity to the law, and I will support that.
Thank you. I'm delighted to hear that. And now, a lot of us have asked about the Mueller report and whether you would commit to providing it to Congress. When asked, I thought you said yes, but when I tried to clarify it, I meant the full report, including obstruction of justice. You again said yes. Then when Senator Blumenthal asked you about the Mueller report, you seemed to make a distinction and said you were going to provide your own report based on Mueller's report, but not the report. This is the way we understood it, but not the report he submits at the end of the investigation. This is concerning, as there is nothing in the regulations that prevent you from providing Mueller's report to Congress. While the regs refer to a confidential report to be provided to the Attorney General, the regs do not state that confidentiality means the report cannot be provided to Congress. So here's the question. Will you provide Mueller's Mueller's report to Congress, not your rewrite or a summary?
Well, the regs do say that Mueller is supposed to do a summary report of his prosecutive and his declination decisions, and that they will be handled as a confidential document as are internal documents relating to any federal criminal investigation. Now, I'm not sure, and then the AG has some flexibility and discretion in terms of the AG's report. What I am saying is my objective and goal is to get as much as I can of the information to Congress and the public. And, these are departmental regulations, and I'm going to be talking to Rod Rosenstein and Bob Mueller. I'm sure they've had discussions about this. There's probably existing thinking in the department as to how to handle this. But all I can say at this stage, because I have no clue as to what's being planned, is that I am going to try to get the information out there consistent with these regulations. And to the extent I have discretion, I will exercise that discretion to do that.
Well, I can only speak for this side, and maybe not all this side, but we really appreciate that. And the degree to which you can get us a prompt report in the fullest possible form would be really appreciated. And I think there has to be a realization, too, among the administration that this is an issue of real concern to people and to the Congress, and we should be able to see the informed information that comes out. So
I understand.
I'm very hopeful. Thank you. Let me ask this question on enhanced. Did my time run out?
But go ahead.
On enhanced interrogation. During a 2005 panel discussion, you said the following, I think, about interrogating suspected terrorists, and I quote, "Under the laws of war, absent a treaty, there's nothing wrong with coercive interrogation, applying pain, discomfort, and other things to make people talk, so long as it doesn't cross the line and involve the gratuitous barbarity involved in torture." End quote. This is a panel discussion, Civil Liberties and Security, July 18, 2005. Do you believe that torture is ever lawful?
No.
Is waterboarding torture?
I'd have to look at the legal definition. You're talking about under the, right now, it's prohibited. The law has definitively dealt with that. I can't even remember what the old law was that defined torture. I'd have to look at that and then, figure out what's involved in it. But Sorry.
Keep going. I didn't mean to interrupt.
No, it's okay, Senator. Sorry.
At what point does interrogation cross the line to the gratuitous barbarity involved in torture? That's your quote.
Well, I wasn't using that as a legal, the gratuitous barbarity. That's what I was I was saying torture is gratuitous barbarity. So I wasn't saying that gratuitous.
Oh, well, that's helpful then. That's helpful.
Yeah.
And you define waterboarding. You know, one would think these questions would never be necessary. I've thought that all my life, and then I found I was wrong, and they really are. Mm-hmm. And I was chairman of intelligence when we did the big torture report, and what I found and what I saw was really indicative of reform. So I think for the Attorney General, knowing the position is really very important. Right. So maybe you could concisely state your position on torture.
I don't think we should ever use torture, and I think that the clarification that was it your legislation of the putting in the Army
McCain's
the field manual?
That's right.
Was important to clarifying where the line is.
Thank you, Mr. Chairman.
Senator Cornett.
Mr. Barr, I want to talk about guns, and I want to talk about China in the 5 minutes we have together. Back in 1992, there was some discussion about your position on Congress's role when it comes to banning certain types of semi-automatic weapons. Sometimes people call those assault weapons. But in the intervening years, the Supreme Court has now spoken in both the Heller and McDonald case and recognized that the Second Amendment confers an individual and fundamental right to bear arms. Could you sort of bring us up to date from your views in 1992 and how they were affected by Heller and McDonald and what your views now are on the Second Amendment?
Sure. I think I opposed an assault weapon ban because I felt that that was really sort of the aesthetics of the gun. And but you know, since that time, Heller has been decided. Actually, before Heller, I did work at OLC on this issue, and I personally concluded that the Second Amendment creates a personal right under the Constitution. It's based on the Lockean notion of the right of self-preservation. It's tied to that, and I was glad to see Heller come out and vindicate that initial view that I had. And so there's no question under Heller that the right to have weapons is firearms is protected under the Second Amendment and is a personal right. At the same time, there's room for reasonable regulation. And, you know, from my standpoint, what I would look for is in assessing a regulation is what's the burden on law-abiding people, and is it proportionate to whatever benefit in terms of safety and effectiveness will be conferred. As I said just a moment ago, let's get down to the real problem we're confronting, which is keeping these weapons out of the hands of people who are mentally ill. And I think all the rest of this stuff is really essentially rhetoric until we really get that problem dealt with in terms of regulatory approaches.
Well, as our colleague, the senator from Louisiana, Senator Kennedy, likes to say, the Bill of Rights is not an a la carte menu. And I agree with that. And I also agree that there are many facets to these mass violence incidents. After the shooting at Sutherland Springs, we found out that the background check system, the National Instant Criminal Background Check System, was not being used appropriately by the U.S. government, in that case the Air Force. And if it had been, this individual who killed 20 people, injured 26 more at a Baptist church right outside of San Antonio, would not have been able to legally get his hands on the firearm by lying. Mm-hmm. But certainly the mental health issue that you mentioned, we've done work there with
fixed NICS.
In the fixed NICS area. We've also done expanded pilot programs on assisted outpatient treatment for people suffering from mental illness, recognizing that it's difficult for any family member to control, particularly an adult, but that providing an opportunity to go to court and get basically a civil order that would require them to comply with their doctor's orders, take their medication and the like. I'm thinking of Adam Lanza at the Sandy Hook shooting, whose mother did not know how to control him as he was getting more and more ill, and only to have him take her very weapon and then kill her and then go murder the innocent children. So right. On China, do you agree with me that China represents probably one of the preeminent economic challenges to America, particularly because of their theft of intellectual property and their exploitation of gaps in foreign investment that we've tried to address through improvement of the CFIUS process, the Committee on Foreign Investment in the United States. But talk to me a little bit about what you see the challenge of China, both economically and from a national security standpoint.
Well, I think they're the paramount economic and military rival in the world. I think that they are very formidable because they take the long view. They've been stealing our technology, and they've been gradually building up their military power and investing in new technologies. I think from a military standpoint, it's very disturbing how much progress they're making, largely based on U.S. technology. I was very, I really thought that Attorney General Sessions was right on target in setting up his China initiative in the department to start going after the pirating of American technology and other kinds of illegal activities that Chinese nationals are involved in here in the United States and even abroad.
Do you share my skepticism at Chinese telecommunications companies like Huawei and ZTE in terms of how that, once in the hands or in the networks of unsuspecting countries, that could be used for espionage purposes and theft of intellectual property?
Yes. In fact, even in my old Verizon days, we understood the danger and would not use that kind of equipment, even though it would be economically attractive. Yeah.
Before Senator Leahy, I'd like to, on behalf of Senator Feinstein, introduce into the record letters that express opposition and concern from groups like the Leadership Conference on Civil and Human Rights, Planned Parenthood, People for the American Way, National Education Association, Alliance for Justice, NARAL, National Urban League, the National Council of Jewish Women, Center for American Progress, and the Human Rights Campaign, and a letter from Representative Paul Gravala. I hope I got his name right, from Arizona. In support, we have letters from the International Association of Chiefs of Police, a letter from the National Fraternal Order of Police, numerous letters signed from 100 former federal law enforcement, national security officials, including 3 former attorney generals, and a lot of U.S. attorneys and heads of the CIA, FBI, and Department of Homeland Security, a letter from the National Narcotics Officers Association, a letter from the International Union of Public Police Associations, a letter from Major Cities Chiefs Association, a letter from the Association of State Criminal Investigative Agencies. Without objection, I'd like to enter all that into the record. Senator Leahy.
Thank you, Mr. Chairman. Just when you just mentioned being at Verizon, during the NSA's metadata program, we also had the PRISM upstream. It required telecom, internet providers, hand over huge amounts of data to the government. And you testified in 2003 that the law is clear that a person has no Fourth Amendment rights in these records left in the hands of third parties. Third-party doctrine. I actually disagreed with you at that time, and I hope you would now, especially as the Carpenter decision that just came down and written by Chief Justice Roberts It says generally requiring the government to get a warrant to obtain geolocation information through cell site location information. Does that change the opinion you had back then?
Well, it sounds like I haven't read that decision, Senator. It may modify my views. I'd have to read the decision. I was going on the Miller decision relating to bank records. But also, you mentioned you were tying this to the NSA collection because, and then tying it to my testimony because.
You had said that no person has no Fourth Amendment rights to these records left in the hands of third parties, a third-party doctrine.
Yeah, that was the.
Which seems to be undercut by Carpenter.
Okay, I'll take a look at that. But
well, then would you?
I don't want people to have the impression that Verizon was involved in.
Would you respond for the record?
Yes, sure, certainly.
And. You said back in November 2017 that you saw more basis for investigating the Uranium One deal than supposed collusion between President Trump and Russia. And by not pursuing these matters, the department is abdicating its responsibility. Just about everybody's debunked the Uranium One controversy. I think probably the nail in the coffin was President Trump's biggest supporter, Fox News, debunked it. Did I miss something in there?
No, actually, you'll notice that there were no quotes around that, and then the next sentence is plural matters. And my recollection of that is what I think it was relating to the letter and the appointment of Huber in Utah to look into a number of things. And the point I was trying to make there was that whatever the standard is for launching an investigation, it should be dealt with even-handedly. Whatever that trigger is should be applied to all. I have no knowledge of the Uranium One. I didn't particularly think that was necessarily something that should be pursued aggressively. I was trying to make the point that there was a lot out there, and I think all that stuff at the time was being looked at by Huber. That's my recollection. I may be wrong on that.
Well, I think the fact that the investigation has been pretty well debunked, we don't have to worry about it in the future. But we do have one thing that's happening right now. The Trump shutdown is in its 25th day. Justice Department has 13,000 FBI agents, 16,000 prison guards, 3,600 U.S. Marshals, 4,300 drug enforcement agents. They're all working without pay. The FBI Agents Association, I realize it's not part of the government, but the association described the effect of the shutdown as a potential national security issue. So let me just ask you, in your years of experience at the department, what impact do you believe a long-term shutdown has on law enforcement?
Well, I think most people involved in law enforcement are. I don't know if the lingo is still the same. They used to be called essential. I think it's been changed to something else. But I think they're on the job. But obviously, people would like to see the shutdown ended, and that's why people want to see some kind of compromise. And you call it the Trump shutdown, but I mean it takes two to tango, and I sort of wonder why.
Only because he called it that in his meeting at the
okay.
White House, and I said, finally, I've got something I could agree with him on, and because Senator Shelby and I had put together appropriations bills that passed almost unanimously in the Senate at a time when they would have kept the government open. That's at a time when it's hard to get something unanimous saying the sun would rise in the east. And I was just agreeing with the president, but no matter what you call it, isn't it a fact that this does have an effect on law enforcement?
Well, not having a wall also has an effect on law enforcement.
Yeah. and not paying our law enforcement people. We both had experience in law enforcement, you at the national level, me at the state level. You don't pay our law enforcement people, I think there's an effect. You have some very dedicated people, but you have some very distracted people. Do you believe that voter ID laws and similar restrictions on voting actually promote democracy by discouraging voters who are not really paying attention to what's going on? I'm going back to a panel discussion you had a few years ago.
Yeah. What I said there was that in that panel discussion, there was a lot of people complaining about the lack of that many Americans aren't educating themselves about the issues and they're passive, and that it was important to, and also that the voting participation was dropping. And I said my position was that the underlying problem is the citizen, the citizen who's not paying attention to public events, not educating themselves about the issues and so forth, and that the non-voting is a symptom. And I didn't see driving up participation as addressing the primary underlying problem. That was my point, and I pointed out that when the Constitution was adopted, the turnout was about 33%, my understanding. So, and then I said, low participation has been a problem from the very beginning. But my view is that voter turnout shouldn't be artificially driven up without also addressing the issue of an informed citizenry, which I think is a problem.
We do have voting laws that guard against discrimination, the arbitrary closing of voting booths in a predominantly African-American area, for example. Mm-hmm. Would you have any problem in vigorously enforcing our voting rights laws that are on the books?
Of what? Vigorously? No, not at all. I said one of my priorities would be that. I think we have to enforce the voting rights. And I wasn't suggesting that voting should be suppressed. I was just saying that the low turnout is ultimately attributable to sort of the I don't know what the word to use is, but the citizenry doesn't seem to be that engaged, in the public affairs of the country.
Well, they are in Vermont. So they are in Vermont.
Yeah,
we have one of the highest turnouts in the country.
That's good. Yeah, excellent.
Thank you.
Thank you, Mr. Chairman.
Thank you. We're going to have two votes at 4:10. Can you go for a bit longer? Senator Sass.
Thank you, Chairman. General, I'd like to return to the disturbing topics of human trafficking and sex trafficking. You've answered a few questions here today. I'd like to look at the November 28th Miami Herald investigative series that I know that you followed into the crimes of Jeffrey Epstein, and I want to quote from that. Epstein, a wealthy hedge fund manager, quote, assembled a large cult-like network of underage girls with the help of young female recruiters to coerce into having sex acts behind the walls of his opulent waterfront mansion as often as 3 times a day, close quote. The report continues, he was also suspected of trafficking minor girls, often from overseas, for sex parties at his other homes in Manhattan, New Mexico, and the Caribbean. The Herald series continues, quote, in 2007, despite ample physical evidence and multiple witnesses corroborating the girls' stories, federal prosecutors and Epstein's lawyers quietly put together a remarkable deal for Epstein, then age 54. He agreed to plead guilty to 2 felony prostitution charges in state court, and in exchange, he and his accomplices received immunity from federal sex trafficking charges that could have sent him to prison for the rest of his life. He served 13 months in a private wing of the Palm Beach County Stockade. His alleged co-conspirators who helped schedule his sex sessions were never prosecuted, and the deal, called, again, this is the Miami Herald, a federal non-prosecution agreement, was sealed so that no one, not even his victims, could know the full scope of Epstein's crimes and who else was involved, close quote. The fact that federal prosecutors appear to have crafted this secret sweetheart deal for a child rapist obviously enrages moms and dads everywhere. On this particular case, will you commit to making sure that there's a full and thorough investigation into the way DOJ handled the Epstein case?
So, Senator, I have to recuse myself from Kirkland and Ellis matters, I am told, and I think Kirkland and Ellis was maybe involved in that case, so I need to sort out exactly what my role can be. But I will say that if I'm confirmed, I'll make sure your questions are answered on this case.
Thank you. The Deputy Attorney General, obviously there have been media reports about the timing of his potential departure post your confirmation, and the DAG, as you well know from your prior history, has a key responsibility in deconflicting different parts of the department. Those of us who've been pressing on this matter have found in different parts of the department a lot of anxiety about the way this was handled, and yet kind of a hot potato of a bunch of people thinking they're not responsible. Right now, Rod Rosenstein has been helping, trying to deconflict some of that, but I'm worried if with your potential recusal, if the DAG also departs, it's not clear who's going to actually deconflict this. So I'm grateful for your pledge that the department will be responsive, even if not you personally.
Yes, that's right.
More broadly than the miscarriage of justice in this particular Florida case, would you agree that justice has nothing to do with the size of your bank account or the number of attorneys you can hire?
Yes.
I agree, and I think that a whole bunch of Americans wonder about the Department of Justice and how we're trying to prioritize, or how we should be prioritizing our responsibility to the victims of sex trafficking who are left afraid and voiceless. In this particular case, many of the women who were clearly victims, trafficked, rape victims, had no awareness of the fact, and I think in violation of federal statutes of victim notification, that this non-prosecution agreement had been agreed to, and not just that Epstein and his co-conspirators were not indicted, but the rest of the investigatory matters of the department were also suspended. It seems truly bizarre. I think moms and dads watching this hearing would like to know that you will pledge broadly to attack sex trafficking as a scourge in our society on both the supply side and the demand side, as these dirtbags demand this, but on the supply side as organizations clearly perpetrate these crimes. Can you pledge to us that this will be one of your priorities at the department?
They can count on it.
Thank you, sir.
I want to associate myself with what Senator Sass said about the Epstein case and the problem in general. And to the extent you can help us figure this out, please.
Yes.
Senator Durbin.
Thanks, Mr. Chairman. Mr. Barr, thank you for being with us. Mr. Barr, my colleague Senator Ernst asked a question earlier, which I'm sure would be asked in virtually every state we represent, what we're doing to stop the flow of narcotics into the United States. She asked about meth, I believe in particular, but about narcotics coming in from Mexico, and your reply was, and I quote, "It is the major avenue of how drugs come into the country. They come across that border. I feel it is a critical part of border security, and we need barriers on the border." That was your quote. I'm troubled by that answer, and I'd like to clarify it, because if we're ever going to have a rational conversation about border security, there ought to be some basics that we agree on. The DEA, which you'll supervise if confirmed, in its 2018 report said, quote, "The most common method employed by the Mexican drug cartels involves transporting illicit drugs through U.S. ports of entry in passenger vehicles which concealed compartments are commingled with legitimate goods on tractor trailers." The Customs and Border Protection's own data shows that customs officers at legal ports of entry seized the vast majority of lethal narcotics coming into this country. In fiscal year 2017, last year we have data, 87% of the fentanyl, which has been identified as CDC as the most deadly narcotic in America, 87% seized in our country coming in through ports of entry, 13% seized outside of ports of entry. So overwhelmingly, when we talk about building new walls and barriers to stop narcotics, we're ignoring the obvious. 80 to 90% of the drugs are coming in through ports of entry. I met with the head of Customs and Border Protection. He said the number one thing we can do is to put technology in the ports of entry to scan the vehicles coming through. Currently, only 17% of trucks and cars coming through those ports of entry are being scanned. 17%. That means 83% of them are just flowing right on through there, bringing narcotics to Iowa and to Illinois. Building a new concrete wall from sea to shining sea doesn't even address this issue. Technology does. I want to reach the point where we open the government and have this honest conversation. Would you reconsider your earlier answer as to the fact that we need to build more barriers to stop narcotics from coming into the United States?
Well, it wasn't tied just to narcotics. It was tied to overall border security.
You said a major avenue for how drugs come into this country. It's not.
I said it was across the border. Wait a minute.
The border is the major avenue, but your answer was we need barriers on the border.
Right, because we need barriers on the border for border security. Part of what we're trying to do is cut down on drugs. It's also illegal aliens. It's also other people from other countries who may wish to do harm in the United States that are coming in. And barriers are part of the answer. And from my experience, the threat is always dynamic. You put technology at the ports of entry, they'll shift somewhere else. It's a moving target, always has been. And I think we need a system that covers all the bases.
I think the reason we cannot reach an agreement with the Trump administration is fundamental to our exchange. And it's this. I don't disagree with you with the notion that barriers from sea to shining sea will at least slow people down. But when it comes to the next marginal dollar to protect kids in Illinois and children in your home state, it's ports of entry. It's technology to keep these narcotics out of the United States. And if we can't really start at the same premise based on reports from the president's own administration, we're never going to reach a point of bipartisan agreement on border security. So I think we're close to agreeing, and maybe it's semantics, I hope not, but I hope that we can agree that if we're going to stop narcotics, it's technology and personnel. The experts tell us that it's not a wall. And I hope that we can move from there. The last question I'll ask you, and at limited time, they asked me about your statements this morning, your testimony, and I thought they were good, responsive in most part. The one thing I'm stuck on, and many are, is this report you gave to this administration in June of last year about the investigation of the president.
You mean my memo?
Yes.
My memo, yeah.
And you said in there, Mueller should not be permitted to demand that the president submit to interrogation about alleged obstruction. You volunteered that. I'm trying to get around this. Okay. It sounds like it was an effort on your part to ingratiate yourself with an administration which is now nominating you for Attorney General. I'll give you one last chance. My time is up. Please respond.
Okay. Well, first, what I was saying there was, again, based on speculation on my part, was that there has to be an adequate predicate. And if he was relying on just the firing of Mueller or the statement about Flynn and this specific statute, those two things, I didn't think it was an adequate predicate. I wasn't saying he may have other facts, he may have other theories that would support it. I was just pinpointing that. Number two, I can assure you I was not trying to ingratiate myself with anybody. The furthest thing from my mind was coming back into government, I can assure you that. And if I wanted to ingratiate myself or signal things, there are a lot more direct ways of doing it than that.
Just for the record, I think you meant the firing of Mr. Comey. I think you said Mueller.
Oh, okay, yeah. What did I say? Oh, yeah, the firing of Comey. Yeah.
Thank you very much.
Yep.
Just trying to help you.
Yeah, thank you. I'll just take a couple of seconds to see if I can help clarify this, because I think it's been a very interesting hearing. So if there was some reason to believe that the president tried to coach somebody not to testify or testify falsely, that could be obstruction of justice.
Yes, under that, yeah, under an obstruction statute, right. Yes.
So if there's some evidence that the president tried to conceal evidence, that would be obstruction of justice potentially, right? Your point is just simply firing somebody, which is a personnel decision, is problematic for the system.
Right, especially if what I'm saying is that doesn't fit under that statute. No, show me some other statute, but that statute, no.
Yeah, okay. Who's next? Senator Hawley. Senator Hawley, thank you.
Thank you, Mr. Chairman. Mr. Barr, switching gears a little bit. Yesterday, a federal district court judge in Pennsylvania struck down the Trump administration's religious and moral exemptions to the contraceptive mandate under the Affordable Care Act. As part of this ruling, the district court judge issued a nationwide injunction to any enforcement or application of these rules. This is a growing trend. We've seen a lot of this in the last 2 years. We've seen lots and lots of district courts all across the country in various contexts, in the immigration context and others, issue nationwide injunctions. And now, of course, for those listening at home, the court, the entire nation is not within the jurisdiction of these courts. These courts are district courts. They reach a specific geographic areas delineated by law, and yet they're issuing increasingly commonly these injunctions that reach the entire country. This is a fairly unusual and fairly recent practice. In distinction to this, the district court judge in Texas, who recently heard a challenge to the Affordable Care Act case, did not issue a nationwide injunction, and therefore allowing the appeals process to take its normal course. And of course, the ACA remains in full effect throughout that appeals process because he did not issue a nationwide injunction. So my question is to you, are you concerned about this growing practice of nationwide injunctions by federal district courts, and what do you think ought to be done about it?
Yes, I'm very concerned by it. Earlier I was talking about this and saying that I think it mistakes the limitation on judicial power, which is a case or controversy limitation, and tries to grant relief to people who are not part of the case or controversy that's being decided. And as you said, it's really started in the 60s, and it's been picking up steam. And the fact of the matter is there are a lot of district court judges, and you can usually find one who somewhere in the country will agree with you. And so major democratic decisions can be held up by one judge nationwide. I'm also concerned that there's another trend, which is the willingness of some district court judges to wade into matters of national security, where in the past courts would not have presumed to be enjoining those kinds of things. And then the appeals process takes a long time, and so a lot of damage can be done before it gets to the Supreme Court and you get a definitive decision. And meanwhile, everything is stuck.
Can you just say more? You're concerned about courts that wade into national security issues where traditionally they have hesitated to do so. Can you just say more about that? What do you have in mind?
Like the travel ban.
Mm-hmm. And the concern there is that,
I mean, the president takes something based on national security, and and the Constitution vests that kind of judgment for that kind of emergency act or act that he has the authority to perform to protect the country. He's politically accountable for that, and yet a judge with a lifetime appointment sitting somewhere in the country who doesn't have the access to the information, has no political accountability, can stop a national security measure, globally, essentially. And it takes a long time to get that sorted out. That's really troublesome to me.
Yeah, I completely agree with you. Let me ask you about another recent case, this one from the Southern District of New York today, in which the district courts ruled that the attempt by the Commerce Department to include a citizenship question on the census is not permissible, and has stopped the Commerce Department from including that on the 2020 census. The department has argued, of course, and the Department of Justice is defending this decision, that including a citizenship question, as was done for approximately 100 years on the census, actually helps identify with greater accuracy the residents of the country who is and who is not a citizen, and of course helps more accurately apportion and draw congressional districts and make sure that representation is fair and the Voting Rights Act is fairly enforced. Do you agree with that position?
Well, it's being litigated now, so I really would prefer not to comment on it.
Do you anticipate that the Department of Justice will continue its vigorous defense of the position that the administration has taken?
I think generally I have no reason to change that position.
Yeah. Thank you, Mr. Chairman.
Senator Whitehouse.
Thank you. Mr. Barr, in order to perform its counterintelligence function effectively, what should the Department of Justice and the FBI know about the business relationships and entanglements of senior officials with foreign interests and governments?
Well, usually, I guess usually investigations are started because there's some act that comes to the attention of the law enforcement agency that suggests someone is being disloyal to the United States.
Except where
we're working for a foreign excuse me?
Except where we require disclosures in order to give the law enforcement folks that advantage of knowing in advance when a senior official has a business entanglement with a foreign interest or power.
Mm-hmm.
So what should we know?
What official are we talking about?
Well, let's start with the president.
Are you suggesting the president go through a background investigation by the FBI?
No, I'm suggesting that when there's evidence that he has business relationships with foreign interests, then that may be a factual determination that would be of some note to our counterintelligence folks.
Well, the financial disclosures that I think are filed by other, I don't even know if members of Congress file financial disclosures, do they?
Yeah.
They do.
So do many officials in the executive branch. So
that's for financial conflict. I don't think that's for counterintelligence purposes.
Probably because very few people have business relationships with foreign interests, so it turns up much more often in a conflict.
Well, business relationship with a foreign interest is not ordinarily a counterintelligence concern.
Unless, of course,
unless the person is a traitor.
Or in a position to make decisions that are biased or influenced by those business relationships.
Well,
counterintelligence and treason are not the same thing, are they?
Counterintelligence, you're usually trying to counter the intelligence activities of another country.
Correct. And you may want to head off things. You may want to be aware of things. You may want to. There are a whole lot of things short of treason that are the counterintelligence function.
Right. Including, counterintelligence focuses usually on foreign intelligence services and their activities.
Trying to American officials off.
I think we're mixing apples and grapes or whatever here, because financial disclosure
maybe we're just having a hard time answering what ought to be a really easy question, which is that when a senior government official has business relationships with foreign interests and powers, we ought to know about it. That ought to be an easy proposition, and in the other administration it would be.
Well, did congressmen go through background investigations to get access to classified information?
That's a whole separate question.
No, but it's exactly the same question.
We do a lot more reporting than we do.
Well, your financial reporting, with all due respect, is not the same as a background investigation. You're elected by the people to hold an office, and you don't get a background investigation to get on the Intelligence Committee.
But we do have to do a lot of reporting. Okay, you don't want to answer it. I'll move on. Let's talk about corruptly in obstruction cases. I'm not sure I heard you correctly, so I want to make sure you have the chance to explain. But it sounded like you were saying that the word corruptly, used, as you said, adverbally, was a requirement that there be some form of destruction or interference with evidence. I have always read that term corruptly in obstruction of justice to impose an intent requirement, which is also what the Criminal Resources Manual of the Department of Justice says, and what I think virtually every appellate court has said. So it worries me if what you are trying to do here is to redefine the obstruction statute by narrowing the intent requirement and using the term corruptly to refer to something very different, which is the actual physical corruption changing or damaging.
I think I can allay your concerns.
Could you do that? Because
if you look at the memo, you'll see that my discussion of corruptly is not up in the plain meaning section where I'm talking about how you interpret the statute. And my basic argument as to why the statute covers destruction of evidence and hiding evidence and stuff like that is based on the word otherwise. The Supreme Court decisions in Yates and Begay, also the fact that if you actually read it otherwise, it swallows up all. It becomes a one-clause so it wipes out everything else.
If I can just cut to the...
So then later on I point out in my memo, I point out that reading is also supported by the understanding of the word corruptly, which the Poindexter case, D.C. Circuit case, I think had the most intelligent discussion of the word corruptly, which is it does refer to the kind of activity that's necessary, which is perverting a proceeding by corrupting it.
So in the event that the Mueller investigation has turned up evidence of obstruction of justice by the president or people close to him, you would follow the Department of Justice's existing legal guidance with respect to what that word corruptly means.
My interpretation of the statute was not predicated entirely on the word corruptly. I was just pointing out.
And it is not your intention to change department policy or department standards or department definitions, particularly as they may bear on obstruction by the president or people around him.
That's right.
Thank you.
We're about to vote. Let's do one more. You deserve a break. You've done great. One, Senator Ernst, then we'll take a break, go vote. I'm going to vote and come back, give you about 15 minutes, and we'll just plow through till we're done. Senator Tillis?
Well, I'll be brief. One question, because people have asked, they've gone to the wall. It almost sounds like they're trying to suggest that you believe that the fix for border security is a 2,300-mile physical barrier from the Pacific to the Gulf. Do you believe that's the best way to secure the border?
I'm not sure what the current thinking is on this, but when I was looking...
Have you ever advocated for a wall or some sort of monolithic structure as the plan for securing the border?
No. But I do believe we need to have a system all the way across. When I was looking at this, there were certain areas where, a wall didn't make any sense.
You've used the word barrier. I don't think a 30-foot wall makes sense on, for example, 1,000-foot cliff.
Right.
Or one that's out in the middle of nowhere. Would you agree that, when we get away from this childish, everybody's saying it's a wall or not, that we're probably, the president's repeatedly said that we need wall structures, we may need steel slat structures, we may need to reinforce chain link fences with all-weather roads. We need aerostats so that we can identify people crossing the border that are otherwise desolate and not very frequently crossed. We need border patrol agents, and we need technology that interdicts all the illicit drugs at the legal ports of entry, that those are all elements of a barrier that actually will better prepare us to secure the border, eliminate the poison coming across the border, and perhaps reduce the amount of human trafficking that's coming through the legal ports of entry. Is that a better way to characterize your position on barriers that either are physical, technological, or otherwise?
Yes.
Thank you. Also, I can't leave without going back to, you were talking about a time when I was in my early 30s. I remember vividly just how dangerous things were getting back in the early 90s. I was 30 years old in 1990. I remember vividly the news reports and everything that we were trying to do to get ahead of the murderous environment that we were in. I think some people are trying to project, or at least maybe I've inferred, maybe incorrectly, but project what you were trying to do or what you were advocating for in the midst of a crisis, which was not mass incarceration of low-level nonviolent criminals.
Right.
On to your view of, let's say, the First Step Act and what we're trying to do today. If you, hypothetical, maybe you can't answer it, but let's say you were Attorney General when we were moving First Step, which I supported. I supported criminal justice reforms in North Carolina when I was Speaker of the House. Are you fundamentally opposed to what we're trying to do with the First Step Act?
No, I think some of those things make sense. If I had been at the table, I probably would have urged a few changes to it. But, you know, overall, I don't have a problem with it.
And you're fully aware the President and folks in the White House are supportive of the act. And
yes.
So you'll do everything you can to help us take that intent, the statutory intent, the things that you'll need to do is implement. In your role as Attorney General, I do believe you're going to be confirmed. To make sure that we get the full positive effect that we'll get out of the First Step Act.
That's right, Senator. And, you know, there were a number of things being lumped together. What I espoused in the 90s, when we had the highest crime rates in our history, was taking the chronic violent offenders with long criminal history records of predatory violence, and especially the ones that use guns in multiple offenses, and getting them off the streets and into prison.
And I think you made the point that in some cases you were able to more clearly present evidence where they were involved in drug trafficking, but you knew damn well that they were a part of what was murdering these communities and making them very dangerous. And the point there was you were using every device possible to get them behind bars and off the streets so that you could make those communities safer, including the communities in Trenton, New Jersey.
Right. Yeah. So the other thing were then there are drug penalties, and some of the drug penalties, yes, were draconian, and there were rational reasons for doing that at the time, and sometimes people got drug, and we weren't going after people who needed treatment, who were, you know, just because they were addicts. We were going after the people who were distributing the drugs, and you know, in the current circumstance. I understand there's data to support what was done in First Step. I understand those changes on the drug front, but I would not let up on chronic violent offenders because they commit a disproportionate amount of the predation in society.
I hope you don't, because they need to go behind bars for a very, very long time. Thank you.
Thanks.
All right, thank you, Mr. Barr. What we'll do, we'll come back with Senator Klobuchar. We're going to take a 15-minute break, and hopefully by then both of us can vote and come back and continue, and we're just going to plow through till we get done today. So we'll be in recess for 15 minutes.
Is this a spelling?